Hello, I'm Dr. Terry Susan Fine, Content Specialist for the Florida Joint Center for Citizenship, which is part of the School of Politics, Security, and International Affairs at the University of Central Florida in Orlando. Welcome to our Middle School Civics Highlights series. Today we look at benchmark CG 3.11, Landmark U.S. Supreme Court Cases. In Part 1, we focus on recognizing landmark U.S. Supreme Court cases. We focus on Benchmark Clarification 1, where students will recognize landmark Supreme Court cases. Note that there is a list of cases that is required for students to know, but at the same time we also have that EG there, which means that there might be other reasons that a case might be brought into the class for discussion because it has characteristics of a landmark. It has characteristics of having a deep, long-standing impact on how the law is experienced after that case is decided. So what are examples of these landmark cases? Let's take a look at what the Florida Department of Education has identified as those landmark cases that are most important for students to know and to recognize. First is Marbury versus Madison. Marbury versus Madison is, by many accounts across the country, across the world, to be the landmark case, that if you learn no other landmark case, you must learn about Marbury versus Madison, because it is from Marbury versus Madison that any other Supreme Court case can play a role in deciding what the law means, because Marbury versus Madison established judicial review. Judicial review is the power of the judicial branch to review the actions of the executive and legislative branches and to determine whether those actions, whether they be laws, executive orders, state laws, state-level executive orders, to determine whether they are unconstitutional. This includes, of course, laws passed by Congress. So the national legislature could decide to pass a law. It could be unanimous, 435 yeses for the House of Representatives, 100 yeses for the U.S. Senate, the President signs the bill, and a majority of the U.S. Supreme Court, 5 out of 9, could decide that that particular law is unconstitutional, is inconsistent with the Constitution. Then we look at Dred Scott versus Sanford, decided 1857. This question focused on citizenship. The case determined that descendants of individuals who were brought to the United States as slaves did not have standing in federal courts, meaning that they could not appear in federal courts as a plaintiff or as a respondent for that matter, because they lacked U.S. citizenship. And the Supreme Court went on to say that individuals, whether enslaved or free, whose ancestors, whose parents, grandparents were brought to the United States as slaves, that because these individuals descended from slaves, whether a person was free or slave, the Constitution did not intend for them to be U.S. citizens. Consequently, this means that these descendants did not have standing in federal court because they did not have this right of citizenship, which is to file a formal complaint in a federal court. Plessy versus Ferguson was decided in 1896, and in this case, the Supreme Court interpreted the 14th Amendment Equal Protection Clause. So the 14th Amendment says that states may not deny to any person the equal protection of the laws. But the interesting question remains is, what is equal protection? And how would it apply in a state-level context? Well, the Supreme Court determined in a 6-to-1 vote that separate but equal segregation did not violate the Equal Protection Clause of the 14th Amendment. the Supreme Court determined that it was constitutional to provide separate accommodations for the white and colored races. So the Supreme Court determined that as long as the characteristics of what was necessary to be equal in a situation that focused on blacks and a situation that focused on whites, that as long as those characteristics were equal, then blacks and whites could be segregated or made separate. So in this particular case, the issue related to the Louisiana Car Act, and the Louisiana Car Act focused on train cars. And in that act, the Louisiana legislature and governor claimed that there must be, not there may be, not there should be, but there must be segregated train cars. So in this particular instance, Homer Plessy, who was the plaintiff in this case, he ended up suing, saying, I was required to sit in a car for black people and I am black. And the Supreme Court said, but you were not denied entry on the train. You were still allowed to travel where you wanted to travel. Therefore, the circumstances were equal even though they were separate. In Brown v. Board of Education, 1954, this case reinterpreted the ruling in Plessy v. Ferguson and thus reinterpreted the 14th Amendment. In this case, the Supreme Court determined that separate but equal segregation did not violate the Equal Protection Clause, except in the case of public schools. The case focused on public schools only, and the Supreme Court ruled only for public schools, saying separate but equal has no place. Therefore, there are some who say that Plessy v. Ferguson was reversed with Brown v. Board of Education, and there are some people who say that Plessy v. Ferguson was not reversed, because even though the separate but equal doctrine remained in place for other areas of life except public schools, some said, well, public schools are in every county, in every state, in every community, therefore Plessy v. Ferguson was overturned. Other people say there was so much other areas of life, including government buildings, that were segregated based on race, that Plessy v. Ferguson was reinterpreted, but it wasn't reversed. Now we look at Gideon v. Wainwright. This case extended and upheld the Sixth Amendment right that all defendants must be appointed an attorney if they cannot afford their own attorney to the state level. So the Sixth Amendment is part of the United States Bill of Rights. So only persons who were accused of federal crimes could be granted an attorney if they so desired one because of lack of funds. But Clarence Earl Gideon, who was accused of a state crime, said that he was entitled as a U.S. citizen to an attorney because of his lack of funds, and the Supreme Court ruled in Gideon's favor. This was a unanimous decision, 9-0. The Supreme Court ruled that yes, whether the crime was committed at the state level or the federal level, a person who's accused of a crime does not, if they have the right to counsel, that means that regardless of where the crime was committed, if it's a federal level or state level crime, that they are entitled to an attorney because they don't lose their Sixth Amendment rights if they are being prosecuted for a state level crime. Now we focus our attention on the remaining four cases: Miranda versus Arizona, In re Galt, United States versus Nixon, and Hazelwood versus Kuhlmeyer. In these four cases, we focus a great deal of attention on how the U.S. Supreme Court interpreted the Constitution, and they also interpreted various elements of constitutional processes and practices. So when we focus on Miranda versus Arizona, for example, this is a case where someone who had Fifth Amendment rights said that he should have been reminded of his Fifth Amendment rights before he spoke to police. And so for that reason, the outcome of this case, it was a 5-4 decision, so the court was pretty divided on this issue. The issue was whether or not someone who spoke to police freely about his criminal activity, whether he should be prosecuted for what he said to the police because he was not aware that this information might be used against him. The Fifth Amendment protects people from the notion of self-incrimination. And so the Miranda rulings include two parts. One part is to remind people that before they speak to police, anything that they say may be used against them in a court of law. But the second part of the Miranda warnings reflect the decision in Gideon versus Wainwright 3 years earlier in 1963, when the Supreme Court determined that if a person could not afford an attorney, that the government had to provide them with an attorney. So that's the Miranda warnings, and that's the outcome of Miranda versus Arizona. Then we look at In re Galt. This case involved a juvenile, and the question was whether or not juvenile court had to follow the 14th Amendment due process clause, and whether or not juveniles had the same due process rights as adults. And the Supreme Court determined that yes, juveniles have the same due process rights as adults, and therefore juveniles then needed to be treated in terms of the various procedures that come with someone being arrested for a crime and accused of a particular crime. In United States versus Nixon, this was 1974, the question before the court was whether or not the president has some executive privilege, meaning that he can, in essence, interpret the law in a way that he's not held accountable to it, or whether or not everyone must follow the rule of law, regardless of the position that they hold. And in this particular case, the United States, in a unanimous decision, the U.S. Supreme Court decided that no one is above the law and that the president was not entitled to limited executive privilege such that he could not withhold information and could not withhold materials from the court that the court demanded. And then finally, we look at Hazelwood versus Kuhlmeyer. In Hazelwood versus Kuhlmeyer, here the U.S. Supreme Court looked at a student speech case. And this can be kind of confusing because the focus of the case was publishing the student newspaper. And freedom of the press is included in the First Amendment along with the freedom of speech and other rights and protections. But it's what students were going to say to be included in that newspaper article that school administrators decided, school officials decided, that the students could not place that material in the student newspaper. So even though it was set to be published and distributed, it was a freedom of speech case because it was what was the context of the speech and not this notion of publishing and distributing this material. Thank you for joining me for Middle School Civics Highlights. Do you still have questions? If so, please contact us using the information that appears on the screen. Till next time, I'm Dr. Terry Susan Fine. Thank you for joining me.